Good day, everyone. I am LORENZANA Patricia Nicole from PCBet 22402P. I'm going to discuss about Chapter 4, Reformation of Instruments, from Article 1359 to 1363. Article 1359. When there having been a meeting of the minds of the parties to a contract, their true intention is not expressed in the instrument purporting to embody the agreement. By reason of mistake, fraud, inequitable conduct, or accident, one of the parties may ask for the reformation of the instrument to the end that such true intention may be expressed. If mistake, fraud, inequitable conduct, or accident has prevented a meeting of the minds of the parties, the proper remedy is not reformation of the instrument, but annulment of the contract. So, reformation is that remedy by means which a written instrument is amended, or babaguhin natin yung written instrument that represent the contract. So, sabi nga ang kontrata ay hindi necessarily written. Kung sakaling may written contract, yung kasulatan na iyon ay hindi ayun yung mismong kontrata. Yun lang yung written instrument na nagre-represent doon sa contract. So, babaguhin ang written instrument if hindi ito tumutugma sa totoong napag-usapan and napagmitan ng minds natin. So, it is not the contract itself being reformed. It is the instrument that represent the contracts. Reformation distinguished from annulment. Reformation presupposes that there is valid existing contract between the parties, and only the document or instrument which was drawn up and signed by them does not correctly express the terms of their agreement. In annulment, there has been no meeting of the minds. The consent of one of the party being vitiated by violence or intimidation or mistake or fraud. So, kapag nagkaroon ng meeting of minds pero dahil sa mistake, fraud, inequitable conduct, or accident dun sa contract na nalagay, the remedy is reformation. Pero kung wala talaga meeting of minds kasi ang isang party ang consent niya was vitiated, the remedy is annulment. For example, si Jack binebenta niya ang kanyang sasakyan for 1 million pesos. And now, ito naman si Rose, ang akala niya is 500,000 pesos lang niyang binibili ang sasakyan ni Jack. So, they executed deed of sales. Tapos, sa contract nila, ang nakasulat ay 1 million pesos. So, meaning, there was really no meeting of minds. Kasi hindi naman talaga sila nagkasundo kung magkano ito. So, the remedy is annulment. Because there has no meeting of minds. Pero kung si Jack, binibenta niya ang kanyang sasakyan for 1 million pesos, and now ito naman si Rose nakipag-negotiate siya for 500,000 pesos. Eventually, pumayag rin naman si Jack. So, nagkasundo sila na 500,000 pesos para sa sasakyan ni Jack. Then, nag-execute sila ng deed of sales. However, ang nakasulat sa kanilang deed of sale is 1 million pesos. So, ang remedy dito is reformation. Kasi nagkaroon naman sila ng meeting of minds na 500,000 pesos, but then ang na-execute nilang written instrument does not reflect the true real intention of the parties. Requisites of reformation. There is a meeting of minds of the parties to the contract. The true intention is not expressed in the written instrument. The failure to express the true intention is due to mistake, fraud, inequitable conduct, or accident. The fact upon which relief by way of reformation of the instrument is sought are put in issue by the pleadings. There must be clear and convincing proof. So, syempre, napaka-unjust and equitable naman to enforce a written instrument kung saan alam naman natin it does not reflect the real or the true meeting of minds between the parties. However, your action for reformation must be brought within a period of time prescribed by law. Otherwise, kapag hinayaan mo siya din yung action to file for your reformation, ay hindi na pwede. It will be barred by mere lapse of time. Actually, the prescriptive period for action based upon a written contract and for reformation of an instrument is 10 years under Article 1144 of the Civil Code. And note also that reformation is available kapag mayroong written contract. Dapat mayroong written instrument. Dahil, ang sabi ko nga, hindi naman talaga contract ang nire-reform but the written instrument embodying your contract so as yung instrument ay mag-reflect ng contract nyo. Article 1360. The principles of the general law on the reformation of instruments are hereby adopted insofar as they are not in conflict with the provisions of this code. So here, the general law on reformation has a suppletory effect. It will supplement the provision under the civil code about the reformation. Ina-adapt din natin yung general law on reformation, but then, in case of conflict between the two parties, syempre yung mag-govern is etong civil code na provision. Article 1361. When a mutual mistake of the parties causes the failure of the instrument to disclose the real agreement, said instrument may be reformed. This article provides a situation kung saan mayroong mutual mistake. Dito dapat ang mistake must be mutual and it must be fact. Hindi dapat mistake of law. Kapag nagkaroon naman ng mutual mistake, then it causes a failure of the instrument to disclose kung ano ang tunay na agreement ng parties, then yung instrument may be reformed. For example, si Jack ay binebenta niya ang kanyang sasakyan na Civic, which is ayun din talaga ang gustong bilhin ni Rose. But dun sa written agreement nila ang naibenta ay ang Fortuner. Kasi nung nagda-draft na sila ng written instrument, nalimutan nila parehas kung ano nga ba ang specific details ng sasakyan na bibilhin ni Rose, like plate number nito. So, ang nailagay ang definition ng Fortuner. So, by mutual mistake ng dalawa, hindi nag-reflect ng true or real agreement yung written instrument nung ginawa nilang dalawa. And according to Article 1361, yung written instrument may be reformed. Either of the parties may file for reformation. Article 1362. If one party was mistaken and the other acted fraudulently or inequitably in such a way that the instrument does not show their true intention, the former may ask for the reformation of the instrument. In this article, the mistake is unilateral, but the other party acted fraudulently or inequitably. The right to ask for reformation is granted only to the party who was mistaken, since the mistake is not mutual. For example, Jack borrowed money from Rose worth 100,000 pesos. Then Rose drafted a promissory note. She wrote 1 million pesos in the promissory note instead of 100,000 pesos, and Jack didn't notice that and he signed. So here, one acted mistake or one committed mistake in signing an instrument, and other acted fraudulently kasi nilagay niya is 1 million pesos instead of 100,000 pesos. So dito, ang true agreement is that Jack borrowed only 100,000 pesos, but the instrument does not express the true agreement of the parties, and the instruments express that the debt ni Jack is 1 million pesos. The reformation here is available as a remedy to Jack only, because Jack is the party mistaken and mistake is not mutual, and Jack is innocent. The person who acted by mistakes may ask for reformation of the instruments. Remember here that after meeting of minds, one of the parties acted fraudulently. Article 1363. When one party was mistaken and the other knew or believed that the instrument did not state the real agreement, but concealed that fact from the former, the instrument may be reformed. The concept of this article is similar to Article 1362. Dito, yung isang party is committed a mistake. The mistake is unilateral. Tapos, yung other party is guilty of concealment. Hindi niya ito sinabi. In this case, only the party in good faith can ask for the reformation, hindi kasama ang party who is guilty of concealment. Concealment of mistake by the other party. The remedy of reformation may be availed of only by the party who acted in good faith. The concealment of the mistake by the other party constitutes fraud. There is a concealment of mistake by the other party. The mistake is unilateral, but the other party is guilty of concealment. This is fraud by concealment. Alam mo na nga mali ang ginagawa niya, hinayaan mo pa rin siya. One party is aware that the instrument does not express true agreement of the parties. Again, the remedy of reformation is available to the party who acted in good faith. and concealed the mistake cannot avail of reformation because the concealment here is constitutes fraud. For example, Jack convinced his friend Rose to allow him borrow her land title to pretend that he owned said property and for him to show at his good old friend to allow him obtain a loan from Lee. Later, Jack pledged his friend property as security to his loan, which was not his prior understanding with her friend. Upon discovering of Rose that her property was pledged as security with Lee, so Rose may take action to reform their agreements. Dahil dito is natuklasan ni Rose na ang kanyang titulo pala ay pinangako bilang security sa inutangan ni Jack na hindi naman ito alam or naunawaan ni Rose. Na ang alam lang ni Rose is pinayagan niyang hiramin ni Jack ang titulo nito para pautangin siya ni Lee. So that's all for my report and thank you for listening.